Hi, everyone, and welcome to Making It Count with Christina and Will, where we explore real ways to make your hard-earned money count today and every day.
No matter your financial goals, we want to offer practical tips and insider tricks to help you accomplish them.
Along the way, we'll learn from our local financial experts,
Answer listener-submitted questions,
and share our own money experiences.
so together, let's make it count.
Hi, everyone, and welcome to Making It Count.
We have such an interesting and important topic today. We're going to be talking about why people need an estate plan in 2021. I think a lot of people have misconceptions about estate planning, right, Christina?
Yeah, I mean, I don't know about you, but it's kind of an uncomfortable conversation. You're talking about death and end of life. To the fact where only 32% of Americans say they even have a will or an estate document as of 2020. And Gen Xers and millennials have the least amount of wills.
Yeah, I read that 78% of millennials haven't done any estate planning. So that leads me to, do you have a Christina? Do you have a will, Christina?
I do have a will. And
It's not me, right?
No, it's not you. And the only reason we got a will is because my husband and I were going overseas or like out of the country, and we had two young kids. So we're like, okay, we have two kids now. We're going out of the country. So I guess we need to do this. So it was almost out of like, we felt like it was a necessity, but I never had one before that.
Yeah, I feel like kids is a good reason. I mean, I think when I think of like my assets right now, there's not a whole lot. I'm pretty early on in that stage. So, I probably should have one because I don't really know where my 2010 Corolla is going, but
Yeah, you don't want it to go to the state.
no, I don't have to go to probate for that.
Right.
Yeah. All right. Well, the good news is that we have some help to get us where we need to be. So let's meet our guests. Our first guest today is Mary Kaplan. Tell us about yourself, Mary.
Hi there. My name's Mary Kaplan. I'm an attorney. I've been practicing in the area of estate planning, probate, and guardianship for about 20 years now. I'm licensed in Florida and Georgia, and I'm looking forward to answering your questions today.
We're so glad you're here.
Yeah, thanks, Mary. And then we also have Emily Ostresh from Addition Financial. Hi, Emily. Introduce yourself.
Hi, everyone. Thank you. Yes, my name is Emily Ostresh. I'm a specialist in the legal department at Addition Financial, and I've been here for about 18 years.
All right, let's jump in with our first question. So we're going to start at the basics. So what is estate planning and what documents are included?
When people think of estate planning, usually they think of wills. That's the first thing that comes to mind. A will is a basic document that will basically dispose of your property, for lack of a better word, when you pass away. You can also specify whether you prefer cremation or burial, and any requests like that. There are many, many other documents that are considered to be part of estate planning. There's a basic document also called a revocable trust that's pretty common for those that may have an issue with probate, which we can get into a little bit later in the discussion. A durable power of attorney is another document that all Floridians need, and probably anybody in any of the states, actually. A healthcare surrogate is another document, very important. It designates someone to have all medical decision-making power for you if you ever become incapacitated. And also a living will. A lot of people get living wills confused with wills. They are two different things. A living will deals only with end-of-life medical decision-making, whereas a will, again, disposes of property upon death.
Oh my gosh, I didn't know that.
I didn't know the
Now I
difference
need to
between that.
know what I have. Oh man, I have some more questions then. Okay, so in the introduction, we talked about only 1/3 of Americans actually have a will. Why do people need a will, and why do you think so few people have them?
So why do people need a will? Well, first of all, if you don't have a will, then the state of Florida, if you live in Florida, will dictate where your property goes. So if you're married, for example, when you pass away and you don't have any children, then your spouse will inherit 100% of your property under Florida law. And maybe you're fine with that, and maybe you're not. If you have minor children, then they have a right to inherit your property. However, if you have minor children, you're definitely going to need a will in order to set up some basic trust provisions for them, because you cannot leave more than $15,000 worth of property to a minor child. If you do that, then someone will have to set up a guardianship of the property. even if there is a surviving parent of that child. I've had a client like that where her husband had left a life insurance policy to their daughter, who was around age 6 or 7 at the time that he passed. And the mother thought, okay, I'll just manage this money for my daughter. No, she had to go to the court and open a court case and set up a guardianship of the property. And still to this day, she's having to file annual accountings every year with the court to account for every dollar of that money. This could have been avoided if they would have had wills with trust provisions in them that held that money in trust for that child until she turned at least age 18. But, sometimes people want to make that an older age. Okay. So that's a good reason to have a will if you have minor children. Other reasons to have a will is that you can designate who is your personal representative, which is the person in charge of all the decision making, like who's getting the money, managing where the money's invested, making sure all your bills are paid off. If you have, some family members that might be good at that, but others that might not be so good, you're probably going to want to specify who that person is that's going to be in charge of those decisions. And you're going to want to make sure that that person is enabled to make those decisions without having to go to the court every time they want to do something. And if you don't have a will, they'll have to go to the court for things like selling off a piece of property or signing some sort of contract. Anything they need to do that's kind of major, they'll have to go to the court and ask permission without a will. So that's another reason you'll need a will. Hopefully that's clear.
So as we've established through the introduction, I don't have anything set up currently. Christina does, but she doesn't really know what's on it.
No.
So it's probably like a sticky note that's like,
Stop
so-and-so.
it.
I'm
No,
kidding.
it looks pretty official. I have no idea where it currently is. So
That's
I
helpful.
think that I know.
Yeah.
So hopefully something doesn't happen to me. But I like totally trampled all over your question, but I don't know where my will is. I have a vague feeling I know where it is. Where is a great place for me to keep my will?
I have mine in a fireproof safe. So,
Oh, that's a good idea.
yeah.
Well,
So-
and this was my leading question too about the wills. And before we started, Emily and I were talking about it, and you were talking about what prompted you to get a will. Can you share that with us?
Yes. My husband and I had never considered it, doing any kind of estate planning. And one day, someone very close to me said, you really ought to consider, we have a minor son, and we were worried about, we had created some kind of very informal document, a guardianship paperwork that we thought was pretty good. And someone said, well, you really need to consider who would be the worst person that you could think of that might take your son from you should you both simultaneously pass. What would happen? And my mind started racing. And he thought, and he gave me really sage advice and said, you really need to make this formal, and you need to go to an attorney and get everything done. And we did. And it was an investment, but it was a very wise investment, and we've never regretted it. So
I just love that question of like, think about the worst possible. And I don't have kids, so I'm sure you can relate to this better, Christina, but I think that's a great question to ask
think
yourself.
of your car. Who would be the worst person to get your car?
Anyone. It would be more of a burden at this point. It's
But
a
yeah.
sturdy one, though. It's a sturdy car.
But that's true. Like, I mean, where do you want your assets to go? Think of like it going to the state and being stuck somewhere. Like, you don't
Right.
want that.
Yeah,
to
and even if you
happen.
don't have kids, just think about like the worst person you can think of getting your money
Mhm.
or
Right.
your possessions. Like,
So fireproof safe for my will. What other options should I consider for storing my will?
I like the idea of the fireproof safe. I do want to say safe deposit boxes, they're secure, but they're almost too secure sometimes. They can be notoriously difficult to get into after someone passes away. With most banks, not sure what Addition's policy is on that or whatever, but with most banks, if the person that you want to get into that safe deposit box has not walked into the branch and signed that signatory form, usually with you present before something happens, then they're not going to be able to get in to that safe deposit box, even if they are named as your personal representative, even if they are named as your agent under power of attorney. We've had these issues happen many times. We actually have to get a court order to open that box, which does require you to open a probate case. And sometimes that's the only reason we open the probate case is to get that order to open that box. And then a lot of times you open the box and it's empty. or there's like one thing in there that's insignificant. So I would kind of recommend against the safe deposit boxes just for that purpose anyway, because you want to have those documents accessible. And for things like wills, you're going to need to know where the original is. You really need the original of that document. So make sure you keep it. I like the safe at someone's home. Just make sure somebody besides you and your spouse knows the combination or knows where the key is.
All right, I'm going to go get a safety deposit box.
So Mary, you brought up probate. So explain to us what it means to go to probate. That's probate court, right?
Yes, it is. So to go to probate means you're opening a court case, like a lawsuit, except for not. It's a court case. You're opening it. You have to pay a filing fee, which can be around $400 if you have to do a formal probate, and it's $350 for a summary, which those are the two different types. We don't have to delve into all that detail. But basically, it's a court case. You have to hire an attorney to represent you. That's a requirement in Florida for the formal probate cases. You have to be represented by counsel, which can be expensive. In Florida, the attorney can take 3% of your total probate estate, the dollar value, as their fee. So that can add up pretty quickly. Hopefully that answers your question.
Yeah, no, I didn't realize how expensive it could be.
Do you have to go to probate, or does the will kind of help you avoid probate?
Okay, so the will itself does not help you avoid probate. And as I kind of referenced earlier, not everyone will have to do a formal probate, which is the one where you have to pay the 3% to your attorney and you have to be represented by counsel. Those are only for people who pass away owning more than $75,000 worth of assets in their name when they pass away. If you have less than that, then you can do what's called a summary probate, which is a shorter form case. It's a little bit easier, quicker. There's not as much that needs to be done in those cases. But still, even though you don't need to be represented by an attorney in summary probate, most people do hire an attorney just because they don't know really how to do it. So that's usually what ends up happening anyway. If you want to avoid the whole probate altogether, what you'll probably need to do is a revocable trust, which we kind of touched on earlier. That's a document we can help you set up where basically it acts like a will and functions like a will, but you set it up and put everything in it beforehand. So before you pass away, you take the steps of putting your property, like bank accounts, like real estate, into that trust, which we help the clients with that. And then everything's done so that when you pass away, nobody has to open a probate case because the trust owns everything. You technically don't own it. So there's no need for a probate.
So Mary, you help your clients draw up these revocable trust documents, or these trust documents in general. And then when they go to seek an account or a bank account where to actually put these funds, in many cases, maybe they come to Addition Financial. And Emily, that's where you kind of help review those documents ahead of the account being opened, right?
Yes. They'll go into the branch or mail them in right now because of COVID. The branch will forward them to the legal department. And that's when I'll go ahead, or me and my team will review the paperwork. We look at trusts, we look at powers of attorneys, some estate paperwork, some guardianship paperwork. And then once we're done with our review process, then we'll forward that back to the branch, and then they get back to the member or the future member.
Yeah, I think it's kind of interesting knowing the whole back end process as well, like what you do after those documents are drawn up. And then also before this, you were mentioning that you've seen kind of an uptick in these things coming in to you.
Yes, especially the beginning of COVID, we saw a huge increase in the amount of powers of attorneys that came our way. And also trusts have been increasing too. It may be that they weren't currently, recently drafted, but that people are now realizing they need to start doing something with them. They may have had them for years and they needed to submit them to the credit union in order to be either added as a power of attorney on the account, or open the trust account, or update a trust account that we currently have.
I think that's really interesting hearing that there's an uptick. And you touched on something that I think it might be a good cause. Like I know for me personally, during this whole year that is the year of 2020, I've been taking kind of like little things that I haven't been getting done for a long time and just like working through them slowly. Like, this is a thing on my task list that I just really have not taken care of. not anything as important as, estate planning, but that could be one reason. Like people are actually sitting back and they're like, oh, I never did this.
Yes, I think that especially right now, and we think of estate planning as more, like you said, Christina, end of life. But right now, we're seeing people who are healthy that just are all of a sudden incapacitated, and they had not maybe considered that they need someone to be able to take over their account or act on their behalf. So we've seen that. We've also seen a lot of older people that maybe their kids have been after them for years to do this type of paperwork in case anything were to happen. And now the current environment is that we really do need that. So a lot of people are bringing them in just in case, or people are sick and they need help. So it's really, we have seen the big uptick.
Do you, since you see almost like the back end of it, do you have any tips or some things that would help move that process along? Or things like, don't do this because this is going to hold up us processing things?
Yes, I would say that if I had to give a tip, I would say to definitely stay away from online forms that you might find. I know Mary will agree with me on this. We see a lot of forms, even ones from Office Depot that are, from a little catalog of forms that you can get for legal documents. I've even seen some LegalZoom, or I've even seen some where they go to a paralegal service that's like a mill and they just kind of crank out these forms. But it's really not advisable because what we're very strict. We follow Florida statutes very carefully, and we review and we look for certain words and phrasing and certain things that are on a attorney prepared power of attorney that is most likely not going to be on a form power of attorney that you'd find online or at a catalog of other legal documents at Office Depot. So
this is not something we should be kind of bypassing or trying to get the Groupon deal for, if you will.
Yeah.
Going to YouTube University for this
no
one.
BOGOs.
No BOGOs.
It's not on the Cartwheel app, Christina.
It's not, darn it. Mary, you're not doing a buy one, get one will for free? No?
Not at this time.
Oh. Well, it sounds like business is probably booming right now. Do you see the same on your end, like Emily was saying?
Yes, we have. It's been interesting this year. There was very few people coming in March, April, maybe May. And now since then, I guess everyone's decided, you know what, this thing isn't going away anytime soon. We really need to get these documents done. We've waited long enough, and who knows when this is going to be over with. And I've been putting this off and procrastinating, whatever it may be. So now we've got everybody coming in, and yeah, trusts are very popular because people really like the idea of not having to burden their family with going to a court or even an attorney. I mean, if you do everything in a trust and you really, cross all the T's, dot all the I's, as they say, your family is really set up and they don't really have to do anything. And it's very easy. It can be.
So as we were researching this topic ahead of the podcast, we came across the word intestate. And that is a very, to me, a complicated word that I really don't know what it means. Can you explain that to us?
Yes, intestate simply means without a will. That's all it means. We have a lot of these little Latin terms floating around out there and people can be intimidated, but really it's just, that's all it means, without a will. So there's a different set of things you have to do in Florida, and I'm sure other states as well, if you're intestate versus testate, which means with a will. So if you do have a will, as I kind of referenced, you get to specify who does what. So who serves as the personal representative and who gets the money, if that's, if you want to benefit some other family members other than who the state of Florida says should inherit your money, you can do that. But also there's other documents and things that we as attorneys have to do for those who are intestate that we don't have to do for those who are testate. So one example of that is this document called Affidavit of Heirs. It's kind of a burdensome document that we only have to do if somebody dies without a will, if someone dies intestate. And that's a document where basically somebody's going to have to go back and trace the whole family tree and list out all your relatives, when they were born, what their current address is. If they die, then what's their date of death? And then you have to get a third party to sign it who's, it could be a family member, but somebody who's not benefiting. So someone who's not inheriting is the person that has to sign that document. and then swear to all its contents, that can be a little challenging. People get real
gosh.
aggravated about that. Yeah.
That sounds expensive too. That sounds like a lot to leave some, especially having somebody do it that isn't even going to benefit from the will at all. Like that's a big ask.
It sure is.
So I have two young children, like I mentioned earlier. Let's talk leaving money to children. Like, should I leave money to children? Should I put it in a will, in a trust? How do I handle that?
So usually the most popular way of dealing with that is most spouses, especially if it's the first marriage and all the kids they have are the kids they have together, those individuals will usually leave 100% of their estate to their spouse. And then the will or trust specifies, okay, if we're both deceased, we want this money to pass down into a trust for our children. And the money will then be put into this trust account and held and managed by the person who is named to be the trustee. Trustee is sort of like a manager. They're not entitled to take the money for their own benefit, but they're managing this money for the benefit of the children. So as long as the children are under the age specified, the trustee will pay all the educational expenses out of that account. They'll pay all the medical expenses, all the daily needs like food, water, clothing, of course. All that will get paid for by the trustee out of that account until the child or children turns the age that is specified in the document. So a lot of my clients like the age 25. They like to say, when my children each turn the age of 25, they shall each receive the principal in this account according to their share. So if there's two kids, the oldest one turns 25, he or she takes 50%. And then when the other one turns 25, they take the remaining 50%, kind of roughly like that. But you can also break it down further if you like to say, okay, they each receive half the principal or whatever their share is at age 25, and then they receive the remaining half of their share when they hit age 30. You could break it down even further if you wanted to. It's very customizable.
So we're talking about trust. And then there's also, I think you mentioned earlier, a revocable trust. Like, what is that?
Yeah. So the revocable trust is a real nice, flexible document that you can draft, and we can draft it for you. Basically, it's a trust that you're setting up during your life. It's also known as a living trust. Some people like to call it that, or they call it revocable living trust. Call it what you want. It's a trust that's sort of flexible and modifiable, that's set up while you're alive. So I have one. So I set it up, and I have moved my bank accounts and my savings accounts into the name of that trust. So other than name, there's no real change as far as I'm concerned. I can still pull money out of my bank accounts. I can still invest in whatever I want to. I could cash it all out and take it to Vegas if I wanted to. There's no real limit. But then
I like that.
Of course you do, Will. Of course you do.
But then it also says that when both my husband and myself pass away, because we have what's called a joint trust, which means both of us have pooled all our money together in this one trust. So when both my husband and I have passed away, then it specifies, okay, my two children will inherit what's in there as long as they've both turned the age of 25. That's what I have. So if one or both of them is under the age of 25 when this event occurs, then I've got my brother, I believe it is. I don't think I even told him that. So there you go.
He knows now.
If he's listening. He'll be managing that money for them until they do turn age 25. I hope that answers the question. That
definitely answers the question. I think it's really great how well thought out that is, and it's manageable. It seems less intimidating the way you just explained it. It's not this scary. A trust sounds very, I think of
it sounds like something rich people have.
Yes.
I feel like that's what celebrities have.
I think of Cruel Intentions and the kids in Cruel Intentions, and they're their trust fund babies. That's what I'm thinking of.
Yeah.
Yeah.
But it doesn't sound like that at all.
No.
Yeah.
So what happens if you become incapacitated before you pass away? People get sick or they're in an accident. How does that fit into the whole world of estate planning?
Well, as I said before, one thing in our department and the legal department is we do see a lot of durable powers of attorneys come through, as Mary was talking about before. unfortunately, we see a lot where someone has assigned or appointed their daughter or their son as their agent. And unfortunately, right now, because of COVID and other things going on in the world, maybe they're separated from their family. They present the power of attorney and it may be rejected for one reason or another. And then it cannot be redone. The person is incapacitated, or they're, behind the lines of the nursing home and no one will let them in, and all of that. We just really advise that everyone try to do this as early as possible when you're, as an adult, try to have a power of attorney. The incapacity thing is really tough, and it's tough on a lot of families.
Do it while you're healthy.
Do it while you can.
Yeah.
Do it while you can. But that the uptick is definitely been pronounced.
I've heard. Now I'm married. Will, you're now married.
Yes.
So I have, and I kind of have a guess on how you have everything set up. Everything in my household is joint. Like our house is joint, our accounts are joint, our cars are joint. Everything is joint. How do you have? Do you have anything with your husband?
Our savings is joint. We have one credit card that is our main spending
our credit
account.
card is joint.
Other than that, no.
So you have separate accounts.
We have separate checking accounts outside of that, but that's really it. So I think I have my own little savings account, and he's got a savings account. So
does he know about that? He does now.
He knows that there's absolutely nothing in it
because you spent it all.
Well, no, because I put it. I've been really good. No, I've been really good. I've been putting it all. Everything that I'm doing right now is going into that a security fund that I told you about. That kind of like we want to have, a fund where. Well, an emergency fund is what I'm trying to say.
Rainy day.
Well, not even a rainy day, but just like I want to have like X amount of months saved up so that like if something happens, we're not, scrambling and throwing everything onto credit cards and going into, even more debt than what my student loans have left me with.
I'm so proud of you.
Yeah.
So for somebody like myself who has everything joint, do I really need a will? Because doesn't everything just fall to my husband anyway? Like is that to my benefit?
So sometimes that can actually work. A lot of people try to do that with joint ownership and kind of a way around this whole problem of probate. Like, okay, I've got some joint owners, so we can bypass the whole court system. No need for attorneys, anything like that. Sometimes that can work. Obviously, there could be problems, things that can come up, like if both of you die simultaneously, for example. That's the first thing, that comes to mind. It's not likely, but it does happen. So if that happens, then what? Okay, so then we're going to have to open a probate, and then we're going to have to figure out who's going to inherit. And if you don't have a will, you have no say in that. The state of Florida is going to tell you where that money goes, and they're going to appoint someone to manage that estate who may or may not be the best person in managing, and they could mismanage it or take money, and who knows if anyone would be able to figure that out until it's too late, etc. Also, you're young, but for older people, a lot of older people try to do that with, let's say, a child. If they've got multiple children, they'll name one child to be the joint owner on their bank accounts. And a lot of people don't say it like that when they come to talk to me. They say, okay, well, my child's on the bank account with me, but all this money is going to go to all three of my kids. And then I kind of have to back them up a step and say, wait a minute, so your child's a joint owner. Well, yeah. Okay, so you realize that all of that money will become that one child's money. Well, yeah, but that child's going to give the money to all my kids.
Not if I was the child.
Okay. And I don't mean to laugh, but sometimes, sure, you can try to get around it and maybe it'll work out. But a lot of times I'm going to tell you that's not how exactly it's going to work, especially in a situation if you're older and that one child is the one who's been taking care of you. Maybe they actually do deserve to take something extra as a payback for all the time they spent taking care of you. Who am I to say? But that's probably how they feel as well. So that may be what ends up happening is they say, no, I'm not going to really do that. I'm probably going to keep part of this and maybe I'll give a little bit to my siblings. And that's where you can have litigation start to happen, where other people feel they've been cheated. So they're going to hire an attorney and challenge this and say maybe there was undue influence, which means, okay, this child tricked my elderly parent into naming them as a joint owner. Or maybe I'm going to say they stuck a will in front of them and told them to sign it. They gave everything to my sibling. all kinds of things can start happening when people feel cheated.
Yeah, emotions come into play.
Mm-hmm.
So earlier we were talking about POA, power of attorney. Another term that we hear thrown around is health representative or health surrogate. What's kind of the delineation between those, and why should we have one?
Okay, so the power of attorney, or durable power of attorney, is a document that deals with financial matters. Sometimes some attorneys will combine the two into one. I don't ever do that. I don't like to do that because I like to have things kind of separated. And a lot of times clients want one person or set of people to deal with the finances, and then another family member or set of family members to deal with medical. And I think that's good to give it some thought and think people have different skill sets. Some people are good with, touchy-feely subjects, and some people are much better with money, or vice versa, whatever. So usually the durable powers of attorney deal only with the financial, and the healthcare surrogates always deal with the medical issues. Does that answer? Okay.
No, that does, for sure. That makes a lot of sense. I like the way that you were describing also kind of the logic behind, like, okay, which, because if my parents were looking at me and my 3 sisters about who's dealing with money the best, it probably, unfortunately, it's not going to be me.
I didn't know there was a difference. I thought the power of attorney handled the health stuff. So I thought that's really interesting. How often, my husband and I did our will, oh my gosh, at least 5 or 6 years ago. How often should we revisit it?
So for someone your age that has small children, I would say every 2 to 3 years, because life changes. Yeah, life changes quite a bit when you're younger and your family's growing, maybe. As your children grow, they may develop different needs. If anyone has a child with a disability, by the way, there are special things that we need to do for that child, because if you've got somebody on benefits that ends up receiving an inheritance, that can really mess up their benefits, that can disqualify them for a while, and you don't want to do that. So in that situation, I would say, please come in and see me, and we'll set up, at the very least, a will with a special needs trust in it. But also, and I meant to mention this earlier, anyone like yourself that has small children, another reason to do a will is to name who the guardians of those children should be if you and your husband both pass away. For other people who might have older kids or whatever, I would say every 2 to 5 years, just take a look back at your will and your other documents just to make sure that everyone that you've named is still the people that you would want to have named in those documents. Because as we know, things change over time. People cognitively decline. As your parents age, maybe you have them named as your agent under power of attorney, but maybe that's not the best thing anymore 10 years later. So it's just good. And also laws change, and it's good to come back and get your documents checked to make sure they're up to date. Because as we were saying earlier, when banks look at documents, they want to see all the statutory language that they are looking for. And if it's not there, that could be a problem. So it's always good to keep your documents updated.
Get them updated and bring them back to your financial institution. Right, Emily?
Yes, absolutely.
I need to do that. I need to because you're right. I mean, right now my parents are still doing well enough where we could trust them with our kids. But you're right. In 3, 4, 5, 6 years, that might not be here's hoping that it won't be. But yeah, you're right. And something that we made sure to do is we asked them first if they wanted to be the guardians, because I think that's also important, making sure that they are up for the responsibility of taking care of children.
I remember my parents talking to me when we were younger, being like, all right, well, we've designated, X family members. And we had no choice in it, but I just remember being like, oh no. That's okay. I won't say who. All right. Well, thank you guys so much. Let's take a quick break, and we'll be back with our Making It Count essentials.
Making It Count is sponsored by Addition Financial. When your want to needs a little know-how, turn to the money experts at Addition Financial.
Just like this podcast, they're committed to empowering our community to make the best financial decisions possible. Count them into your financial journey at additionfi.com.
Federally insured by the NCUA and an equal housing lender. All right, we're back. And now it's time for our rapid fire round. You guys ready?
Mm-hmm.
All right. So, Emily, this one's for you. At what age should people make a will?
Well, like I said, I didn't have one until much later in life, but I think it's a much better idea to have it earlier. As soon as you start having a full-time job, that's probably a good time to start. You'll need to look at it from time to time. As Mary was saying, things change, laws change, your family allegiances change. But it's always a good idea to keep revisiting it. My son keeps saying he wants to be a professional video game player, one of these kids that makes $1 million before he's, 20 or something. So, as soon as any even young kids, as soon as they start making enough money and it's substantial, they should look at doing that too.
All right, Mary, this one's for you. What happens if you own property in a state other than Florida or in more than one state in general?
So if you have this issue, please come and see myself or another estate planning attorney. You will probably need to do a revocable trust, and that's revocable living trust, as we talked about earlier. That way you can avoid having probate here in Florida and in the other state. That is what will happen if you don't do anything. Yes. And that means that your probate fees and your attorney fees might be double or more, depending on what state the other property's in and what their laws are like. And as I said, I'm only licensed in Florida and Georgia, so I couldn't tell you how expensive it is to do a probate somewhere like California or Hawaii, but I have a feeling that it's probably very expensive.
Well, along those lines, Mary, what about a timeshare?
Yes, and I'm so glad you asked because I get this issue all the time from clients whose parents or other relatives died and they were a resident of Illinois or Ohio or somewhere else, and only thing they owned here is a timeshare. And I have to deliver the bad news that, I'm sorry, we do have to open an ancillary probate here in Florida just for that timeshare. And a lot of times they're not too happy to hear that because sometimes they don't even want the timeshare. But in order to clear the title and to get that deed back to the timeshare company, they have to open an ancillary probate to get the title in their name and then give it back.
Wow.
Mm-hmm.
All right, Emily, back to you. Is it ever a good idea to draft a will or any of these documents on your own?
No, definitely not. I think that because it's a legal document, you really need to go to a specialist to make sure that they use the proper language. State to state, it may change too because of the laws. But you would really hate to go to, like a paralegal. I'm going to botch this, but I'm going to keep talking. You'd really hate to go to a service that or even I've even seen some notary services that will supply paperwork for you to do. And you'd really hate to do that. And then it's something you can't use in the future. So if your estate is simple, it's not going to cost much to hire a real, reputable attorney like Mary to help you.
Yeah, I think, we all want to think that we're Elle Woods from Legally Blonde, but we're not all getting into Harvard for that. So
and have her wardrobe.
Like it's hard?
Like it's hard.
So, Mary, it sounds like getting your estate or will is more of an investment that we should do. How much should we set aside to do estate planning?
Well, that depends on how large and complex your estate is. But for most people, it's not prohibitively expensive. And if you come and see me, I do initial consults for free, and then I will quote you a flat fee. That's fairly affordable. Of course, depends on your situation. So I can't really quote a dollar amount here and now, but you're always welcome to do comparison shopping. If you want to shop around and get the best fee, we're very competitively priced. And as I said, we do everything flat fee, so we don't bill by the hour for these type of documents.
All right. Well, thank you both so much. I feel
thanks, guys.
much more informed about estate planning than I did before we started.
Yeah, definitely. And Mary, if somebody wants to get a hold of you and start that process like Will, how can we get that process started with you?
Please call my office at 407-494-6701. My assistants would be happy to book an appointment for you. And as I said, our initial consults are free. So if you decide not to go forward, you won't be charged anything.
And we'll make sure to put that information. Lauren gave me the thumbs up. We're going to put that in our show notes. So if you want that, well, you can find it right there. Thank you guys so much. This has been so enlightening and so informative, especially I'm going to go one. Well, no. Well, we'll keep that for what did I learn today? Because I learned so much today, Will. But thank you guys.
All right. So it's time for our favorite segment.
What did we learn today?
All right. I'll start. I I think that I learned that even though, I am joking about my Toyota Corolla as my main asset, there are other things. And I want to make sure that if something were to happen, people in my life aren't struggling to figure out what to do with everything. So I think it's not about, even though it's a not fun thought to think about end of life planning or estate planning, you have to do it for the people you love. It's not about you so much.
Yeah, it's a very unselfish thing to do. You're doing it for the people that you love to make it easier for them.
Mm-hmm.
What I learned several things today. I learned that I need to look at my will again because it's been like 5 or 6 years. Yeah. And my next thing is I have to find my will. And the third thing is I need to go buy a fireproof box because I have no idea where it is in my house. Which like the fireproof box should have like the house information. Like, oh my gosh, like Will, you know how prepared I always like to be. I feel like I'm so unprepared. So learned so much about that today. So each week we give our listeners resources that they can use to make it count in their own lives. And this week we have 3.
That's right. The first is an estate planning webinar from the Kaplan Firm. It goes into greater detail about everything from probate to revocable trusts to HIPAA regulations and how they impact medical proxies. It's available on Addition Financial's YouTube channel, and we'll link it in the show notes.
Our second resource is actually an episode from our first season that focuses on retirement strategies for people over 40, and we'll link that episode in our show notes as well.
Finally, we have an Addition Financial blog post that includes advice from financial experts about setting and sticking to retirement investing goals, an important part of estate planning. That link is also going to be in the show notes.
Our show notes are so important.
It can be quite robust this episode.
It is. You can find even more resources related to savings, investing, and retirement by visiting additionfi.com/resources. We'll see you next time on
Making It Count. And that's a wrap on this episode of Making It Count.
If you learned something new, were inspired to reach your financial goals,
or just found us entertaining,
please subscribe, share, or rate, and review us on your favorite podcast app.
And don't worry, we'll be back soon with another new episode of Making It Count.